In this video, we're going to look at securing data by law, which is the third learning objectives. Remember that when in previous learning objectives and previous video, we talked about written authorizations in terms of patients. Stipulating how they want their data to be used, how who their data could be disclosed to, and who you can share the data with. However, there are situations in which uh, written authorization may not be required, especially when it comes to disclosing to law enforcement or to government or authorities. So in some situations, patient's written authorization is not asked ahead of time. And such disclosures, when they do happen, is usually limited to the requirement of whatever specific law. As you guys know, you have HIPAA, but you also have other laws, and some of the times, the things that the other laws may be requiring may kind of overstep HIPAA or things like that. So there are ways of deciding, okay, what requirement of the law applies in this particular scenario. So that's why I'm using the term may. It may not apply, it may apply. So it's basically on a case by case basis in determining whether this disclosure does not require written authorization or prior authorization, or which can just go, the patient has to consent to. But before making that decision, one of the things to start with is verifying the identity and authority of the agency or the individual that is asking to see this PHI without the authorization of the patient. So some instances in which a written disclosure may not be required includes, like I said, it's really on a case by case basis. Some instances which may not be required would be in public health activities. It could be victims of abuse, judicial proceedings. It could be in organ procurement. If there's a determination that there is purpose of security, possibly national security or safety, stuff like that. So it could be in cases of disaster relief on issues like that. So basically it's on a case by case basis in determining whether it would be possible to release a patient's information to government entity without it having be without the patient having consented to their data being used in that way. So, some of the laws and regulations that exist in terms of, securing the data of PHIs includes the very, very popular HIPAA, which is the Health Insurance Portability and Accountability Act. And HIPAA was signed into law in 1996, so it's been quite a long time now. And one of the things that HIPAA did was to establish national standards. And what that does is to protect individuals' medical records and other personal identifiable information. So I have provided a link about HIPAA. This is a very, very concise material that looks at HIPAA. There's also a assigned video that kind of looked at HIPAA as well, and you have assigned reading that looked at HIPAA. You have additional viewing as well. Please watch all the videos and read all the materials just to kind of get a much broader insight about what HIPAA is, since it's quite a voluminous law that looks at a lot of aspects of health data. And then we have the High Tech Act, which was signed into law in 2009. So, what the High Tech Law Act did was it kind of modified HIPAA in an extent, but it kind of focused lots more on electronic records, electronic data. And one of the things it also did was to try to push for the adoption of electronic health record through what it called meaningful use. So you see that in one of the videos that I was provided in the additional video that looked at meaningful use under HIPAA and how that's kind of try to get the use of electronic health records across the US so that as much as possible everyone is using it. But beyond what high tech did with meaningful use, it also improved the security and privacy protection that was on that electronic health record. So also I've provided a link to that so that you can kind of read through and understand a bit more of what that law is about. And then we have the California Consumer Privacy Act. So the CCPA is not only about health data. It kind of looks at Consumer Act and consumer privacy laws. So it goes beyond health data. It basically goes a bit further than that. It was signed into law in 2018, and so it provides some additional protection that is not fully covered in HIPAA or high tech. And one of the things that it does require is that it kind of requires a business to have privacy policies on how they're going to exercise some of the rights in a way to protect consumers' rights. So you have some of the that being right to know what consumers have a right to know about the business, and what the businesses have a right to delete, or what the customers have a right to delete, and things like rights to out of sales. A lot of the times you will see that in many organizations, you by default it's opting for marketing. So what you're now doing is basically opting out rather than opting into. I think one of the things that some of these privacy laws did was to require whereby um, consumers are making conscious decisions to opt into rather than to opt out of, because when you're opting into it is a more conscious informed consent that you're giving than when you're kind of opting out. So that's one of the things that he looked into. And then it has rights to non-discrimination. Please click on this. The link has been provided also to look at what the CCPA, what provisions of privacy that is under that. Um, Once again, there's a lot of materials under assigned reading. There's a lot of materials under require additional viewing that looks at CCPA as well, so that you can help in broaden your understanding of what this act is about. And then lastly, we have the General Data Protection Regulation. So this is specific to the European Union, which is to say that it does not apply to Americans that live in the US. However, if you as an American, you travel to any country in Europe, some of the protections that are provided under GDPR may apply to you. They are if you're an American who's going to the UK, for example, with the UK leaving EU, it may not fully apply. So it's one of the things to also look into in terms of what happens with the GDPR now that the United Kingdom is not part of the European Union. I'm not saying that you guys should try to investigate that. All I'm just saying is some of the times laws can change, or what coverage that the person may get can change, determining decide depending on what political changes that may happen. So with the UK not being on the EU anymore, this GDPR may not fully cover Americans who are going to the UKs or something to bear in mind. So that's where we end for today's class. Please remember to use the Q&A board. If there's any part of this lecture, whether it's in the first learning objectives, the second learning objective, or in this last one, that you need further clarification on, or if there's any part of the assignment that you need more explanation on, please use the Q&A board, and I will respond to all posts. Do you have a lovely day?